The next issue that we would have, Your Honor, is we want to make sure. There have been times where counsel has asked to approach, but he still wanted to be on the record. Our position going forward is that unless it is something having to do with an issue with the jury, the prior times occurred before the jury was selected. Counsel made certain arguments in open court, then he asked to approach, and he made different arguments, but he wanted to do it on the record. Unless the court orders it, and there's a good reason, the last time this happened, Your Honor, as the court is aware, counsel elected at his request to give a speech that he was very happy with this jury, wanted it to be known that he was happy with the jury.
Give a speech to who?
Stop, don't interrupt.
Oh, okay, fine.
You'll have a chance.
No, I know, but he should.
You'll have a chance.
Wait
till he finishes, then you will have a chance.
I know what he's doing right now.
Do not interrupt either of you. Neither of you interrupt the other.
He said, I need to say something in open court. And then he made a statement about how they were very happy with the jury. Clearly, it didn't matter to the court. He then asked to approach. When we asked to approach, he said he wanted to do it on the record. On the record. But outside the press, he then complains about the jury selection, about a specific juror, etc. We are not going to participate in Mr. Tacopina's attempts to manipulate the media. Again, that ties into the fact that when the case started, I very kindly said to Mr. Tacopina, hey, listen, I know you've been speaking to the media before trial. There was no order, you have every right. Are you going to be saying anything once the trial started? He assured me in front of my co-counsel, the response was, John, I would never do that. I won't be saying anything to the press. Meantime, he is speaking, I already sent the court this, he's speaking to TMZ, he likes to say things to the press as he leaves the building. We took him at his word that he wasn't going to be talking to the press while the pendency of this trial was going on. This is necessitated as an example. We ended up hearing his arguments basically about the jury issues repeated by Al Sharpton. We're not going to try this case in the press. We're going to ask the court at this point to order Mr. Tacopina to not speak to the press during the pendency of this trial.
Okay, I guess I'll start in reverse. First of all, I'd like him to provide a quote of what I said to the press, because one thing I've never done is speak about the facts of this case since the jury's been out. Never. Okay? But I do have here a quote from the District Attorney, Mr. Hoffman, who did quote to Extra that he appreciates any time defense counsel is pretty sure they're going to prevail, but we don't bring cases unless we're very sure we can win those cases by establishing and meeting our burden of proof beyond a reasonable doubt. I believe that when we see the evidence that's going to be presented in this case, we'll meet that burden. So that's their District Attorney. Okay? So I should be able to rebut something like that. That's different. That's saying we're going to win the case, we know the evidence, and we'll meet our burden. I talked about nothing other than potential issues with the jury. I didn't speak about the facts, I didn't speak about Mr. Efron. And I won't do that. Now, the last thing he said was I spoke to TMZ. Again, I defy him to provide to the court what I spoke about, because I didn't violate any order. First of all, there's no order. But I know enough not to speak about the facts of the case. By the way, I didn't opening statement to the jury. Certainly, I would never say anything outside of that opening statement, but I didn't even do that, Your Honor. I simply talked about the issue with the jury. And the reason I did that is because he just did again what he did the other day. Stood up and said, we're not happy with this jury. Try and get that message back to the jury that we're not happy with them. That is not the case. But, Your Honor, the reason I raised the issue about maybe we would have selected a different jury, or certainly a different juror or two, is because of the late disclosure of the ballistics report after the jury was impaneled. And we have a right to make that record. It doesn't mean I'm unhappy with the jury. So, speaking of disingenuous, we're going to now get into disingenuous. But I did nothing but protect the record, protect my client. So that's first and foremost. So again, the issue that I spoke about off the record was caused by their late disclosure of a report that was generated over a year ago by their lead detective in this case, that Mr. Lewin wants everyone to believe he just stumbled upon 3 days ago. He just stumbled upon
Don't
3
yell.
days ago.
You don't have to whisper, just talk.
Try to get that middle ground there.
Just talk in a normal tone of voice.
That he just stumbled upon 3 days ago. You know, he made all these accusations about that's disingenuous, I don't believe it. Well, I don't believe that they just found that report from their lead detective who they interacted on a daily basis in this case 3 days ago. I don't believe it. That was done in January 2020.
I already made findings.
I understand.
In my view, nothing nefarious. I don't want to go over things that we've already gone
Well,
over.
we just did. We still haven't.
He's asking that that both sides be directed not to make comments to the press. That's what he's asking for now. I'm not poking fingers. I'm not accusing anybody of any unethical conduct. Let's just move forward. Here's what I want to
I
ask.
have more things.
Oh, go ahead.
All right, I just listened.
Go.
Now, we've heard all about the discovery issues about, this not being enough. I mean, I think this is incredibly detailed when it comes to Mr. Phillips, especially if this is a videotape. This is really detailed. Tell what he's going to observe at the scene, what he's going to testify to, what he observed at the scene. Putting that aside.
Based on what I've heard, I am satisfied under the circumstances that both sides have satisfied this discovery rules.
So
there's no reason to go over about whether you have complied with discovery. I already found that you did.
Okay, now I want to talk about Ben. There was a police officer, the first one out of the box, Sergeant Zizzo.
Right.
The only thing we have from them, because, I assume the rules apply to both sides, right? The only thing we have from them is a few-line email saying we spoke to him on Wednesday. He testified Friday, recall. We spoke to him on Wednesday, and Jack, you have the email? I heard it. Here's what we have from them on Officer Zizzo. That they spoke to him on Wednesday, which the officer denied on the witness stand, by the way. He said the first time he spoke to him on substance was the day of his testimony. He said that he advised the district attorney that he responded to the shooting while on patrol, and it's common occurrence that the receiver called the shooting and responded only either to find no evidence or the victim, but also sometimes find out whoever called was intentionally misrepresenting. 2 sentences. That's the discovery. He testified that 1, he may have missed the bullet casings, and 2, he didn't know where to look. 2 sort of important things and he didn't search the entire street. That was not in their disclosure. Not their disclosure at all. But yet I'm being accused of not giving them the right information. First of all, I don't have the date. There's nothing in their disclosure that they interviewed him Friday before his testimony. We don't even have that interview. We don't have that date. We have Wednesday only. The witness said, no, I didn't speak to him on Wednesday or something. That was just about logistics.
Right.
Okay, so before we start casting aspersions, I wasn't going to even raise it, Mark. Just happened. I understand this is trial. But, being that we're now throwing stones, let's call the kettle black.
Let's not throw stones.
Well, I know, but they started. So I'm going to respond.
This is a no squabbling zone.
Oh, after he swallows. Well, I'm swallowing back.
Well, you're a good squabbler. You're doing a good job squabbling. All right. Regarding what Sergeant Zizzo testified, did he write a report?
He did not write the report, Your Honor. But he obviously was wearing body worn video, which was
That's been provided.
that was provided
All right.
years ago.
You're an experienced attorney. All of you are experienced attorneys. Sometimes, a witness will say something that is not in a report. That's to be expected. A report is a summary, a sum and substance of what the witness said. It's much more fleshed out when the witness is on the stand.
Well, I agree with that. I'm okay with that. I'm not even going to raise the fact that he said he didn't speak to him on Wednesday and he almost spoke to him. I don't do that. It's petty to me.
It is petty.
But I want to make sure that what's good for the goose is good for the gander. That when Mr. Phillips testifies and he says something, a word that's not in this thing. It's not like, you didn't tell that to the lawyers. It's just not right. This is not a transcribed statement. There will be nothing outside the scope of this. But the same way I didn't get anything from them regarding, I may have missed the shell cases. I didn't get a report that said that or a statement.
Again, to be repetitious, I do not find either side has violated any discovery statute or any discovery rule. Regarding the press, the jury has been told not to read or watch anything about this case. I'm going to assume that they follow that rule. But what I am concerned about is someone that the jury knows is going to read or watch something about the case and then relate it to the jury. So, here's the rule. I don't want any attorney in this case saying anything to the press while the case is going on. That's it. So you can call it a gag order.
We will advise, obviously, courts where we've said nothing. We will advise the DA as well. To be clear, the DA responded to Mr. Tacopina's published report where he dared, quote, Nathan Hockman can try the case himself. But we're going to tell the DA.
Let's move forward. Yeah, just let everybody know in your office who may say something. Tell them not to say anything to the media or the press.
Will do, Your Honor. We had two last issues which are brief. The first issue is we're going to request, we made this request before. Counsel and I've tried many cases in front of the court. If there's anything even close, I 402 in advance. If there's any evidentiary issue, which is even a close call, in terms of the defense introducing, bringing up, asking questions, we want to make sure that they have to approach and that we 402. We don't want to be in a position to have to unring the bell.
That goes for both sides.
Finally, Your Honor, the court is aware. On Friday, it doesn't really matter what the circumstances were. Mr. Tacopina literally started screaming at me in the... So again, Your Honor, I have not interrupted Mr. Tacopina's life. As I see, Mr. Tacopina makes noises. Again, if there's got to be a certain decorum, we're following it. But you can't bring a knife to a gunfight. So we would appreciate, as the court is respectfully instructed, and when one lawyer is talking, the other lawyer not interrupt. Mr. Tacopina, as court is aware, started literally screaming at me in the courtroom. He basically appeared to challenge me to a fight. And again, I've been doing this longer than he has. I've not had that experience occur before. I am not going to be treated that way by anybody. I'm certainly not going to be treated that way in a court where I practiced for more than 30 years and in front of a judge I deeply respect. He doesn't have to like me, he doesn't have to get along with me, but he cannot be screaming at me, whether on or off the record. The court was here. The court, I mean, everyone heard and saw it. It's not right. So I'm just asking that the court, again, Mr. Tacopina is an emotional guy, that the court advise him.
And you are both of you are zealous attorneys, aggressive attorneys, both of you are.
We are. The difference between zealous and aggressiveness. The court has not heard me yell or scream at anybody. And again, and it's not a request. I'm not going to take that.
All right. Why don't we do this? I did not hear you yell. Maybe I did not hear it. If it did happen, it wasn't in my presence. Because you two have this relationship, why don't you not talk to each other unless it's on the record?
Oh, that's...
And then I am involved.
That train is still... Yes, absolutely, I agree with that. But I want to respond now. Because, I can't have it always one way. He makes a record, disparaging remarks, and then I got to sit here. So, no one screamed. You were right there, Your Honor. What's happened, and Mr. Siegel was with me, is Mr. Lewin comes up with his little scolding, sort of bullying attitude, telling me we don't know the rules here, and we're not doing this right, and he didn't like the opening statement, and so on and so forth. So I responded. I don't need a lecture from him. Okay? I'm not going to go into the amount of phone calls I got regarding him and his reputation before this trial started, from lawyers I don't even know, including lawyers inside the District Attorney's office currently. Okay? I'm not going to go into it, Your Honor. I'm not petty.
Wait.
No.
No, and now you're interrupting him. Just that, you were complaining about him interrupting you, you're interrupting him. Don't.
I'm not going into it, Your Honor. I just don't want to do that. But, please, there was no one yelling. You were right here. There was an argument between both sides. Both of us. I agree. That's not going to happen because I'm not going to speak to get off the record. So you're right about that. That's number one. Number two, I have to also raise an issue, and I'm not past that. I don't want to even talk about that anymore. Your Honor's here. That's the end of that. Mr. Lewin did something last week that was inappropriate. And the reason I'm raising it is because I don't want it to happen again. This week, Mr. Mayor's significant other may appear here. Last week, Mr. Lewin, as his playbook apparently, one of the lawyers, went up to my client's family and told my client's family that's not personal, but they should really, hopefully he's really thought about taking a plea because he was facing a lot of jail time, and saying things that played on the emotions of the family. He should have no communication with the defendant's family. I've heard he's done that in every case. That's right here. Well, I don't want him, and I want the court to instruct him not to communicate with anyone on this side of the fence. Not the client's family, not the client's relatives, not the client's friends, because it's inappropriate.
So, Your Honor, so what happened was I walked up very kindly to the defendant's mother and sister, and I said the following: listen, I'm very sorry that you're having to go through this. I have a kid myself. I have siblings myself. I know this must be difficult. It's not personal. And I'm truly sorry for what you are having to endure.
All right.
And then I said as follows: I hope that your brother and your son, I hope that he's really evaluating what he is risking here, because it is a lot.
All right, there's nothing that prohibits...
At the time...
I've heard enough. I've heard enough. There's nothing that prohibits what Mr. Lewin did. You've heard now that the defense does not want you to approach anyone from that side, so don't approach anyone from that side. It's as simple as that. All right.
Your Honor, okay. There's just one evidentiary issue we need to deal with.
Another one?
Yeah, unfortunately,
What is it?
Mr. Lewin bring up
What is it?
402 every moment. I just want the record clear on this.
What is it?
It's that the defense doesn't need to preview our impeachment material on an eliminate motion. Mr. Lewin keeps saying we need to bring it to the court's attention or his attention when we plan on introducing or using evidence so that he can have a 402 hearing. The law is crystal clear. If I don't need to go further, I won't. We're on the same page. But the law is crystal clear that there's no rule of law that would require the defense to disclose evidence gathered by an investigator who may tentatively be called by the defense for impeachment purposes. That's Hubbard versus Superior Court. I'll continue. People versus Hunter. Section 105, 4.3, subdivision A1 provides that, quote, defendant and his or her attorney shall disclose to the prosecuting attorney his or her intended witnesses together with any relevant written or recorded statements of those persons or reports of the statements of those persons, which we complied with. But the court goes on, but that does not include impeachment statements.
All right, go ahead.
But that does not include impeachment statements a defendant obtains from prosecution witnesses. The prosecutor is not entitled to statements impeaching prosecution witnesses. That's People versus Hunter. People versus Sloan. Here, the defense, the court noted, could use the messages on the tape to impeach a witness without disclosing the tape to the prosecution. The prosecutor was wrong that using the tape for impeachment was the same as introducing it into evidence. A few more cases. People versus Ledesma. The court noted, to the extent the evidence at issue was admitted to impeach, counsel may have been unwilling to give the prosecution the benefit of a preview of the defense case in order to obtain such rulings, which is what apparently Mr. Lewin is seeking to do now, but the court noted that the defense was appropriate in the way it proceeded. Two more. Izaga versus Superior Court.
This is Izaga, yes.
Right. The defense is not required to disclose any statements it obtains from prosecution witnesses it may use to refute the prosecution's case during cross-examination.
And you're going to mention Tillis.
I'm going to mention Morrison, in which the court noted, nor did the discovery statutes obligate counsel to disclose she would impeach a witness with evidence of prior misconduct, particularly in that case, gun possession. Now, I understand, Your Honor, that the prosecution here wants us to do their homework for them, but the law doesn't require us to. For that matter, all of the impeachment material that we have arises from their own discovery.
All right, let me tell you my view on impeachment. I'm aware of Izazaga, but that's a California Supreme Court case. There's another California Supreme Court case that's called People versus Tillis, T-I-L-L-I-S. Both of them say the same thing. Impeachment evidence does not have to be disclosed. Impeachment witnesses, once the decision has been made to call them, does have to be disclosed. But the evidence does not. All right, we are at 5 minutes to go. I don't want the jury to wait, so let's give Kathy a break, and if anybody wants to use the facilities, they can. I want to get started right at 10:30.
I just have one thing before we wait for just logistics.
What's logistics?
Not controversial.